Anyway, so what are your plans? Sasa kama tunaanza kufanyia maybe hizo zitakuwa ni zangu. Nataka kusikia pia.
I want to go to the jurisdiction of this court.
Mimi nitakuwa na plans zangu, but
The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this Honorable Court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6), when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional oversight over the National Assembly, so that the National Assembly will not be hard to say that this is a political question beyond the reach of the court. This court, the breadth of its constitutional and supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I hear telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number 1, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment and you are satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with the process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitioners. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues, because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues. The first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Munyi Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mwongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavits that was sworn by the 5th, 6th, 7th, and 8th petitioners, Your Lordship, they do confirm that they came to realize that the extension was given after, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is our humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where, of course, the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments and for connected purposes. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional appointment, because he actually says that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So, in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So, an appointment under this Constitution, that is Section 3, an appointment under this Constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority in this case was the President. So, after appointing Professor Kithure Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complied completely in all aspects with this Act, save for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this presidential memorandum of nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the issues mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this presidential memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following document, and which Senior Counsel Paul Muite said that it was done in an ungodly spirit. So, Your Lordship, I want to reiterate that the essence of this Act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure, even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6(4), approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President forwarded this memorandum of appointment. So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further says, in forwarding this nomination, that, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the President arises. So, Your Lordship, within 14 days, of course, this was done within a few hours, It was the impeachment was done at night, and in the morning the president did this act. So the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave 60 days for Parliament to consider the appointment of the new nominee. And the reasoning, Your Lordship, is there are these documentations that have been given by the president forwarding the nominee. Parliament was under an obligation to consider those documents within a period of 60 days. Your Lordship, by midday on 18th of October, Parliament had already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6.4 that required the public was to be given at least 7 days so that they can give their issues in terms of the suitability of the deputy president nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National Assembly, in their submissions, they have filed, or rather they have given a ridiculous response to these submissions that we made. And under paragraph 361 of their submissions, they say that, in fact, this was a sui generis, procedure, to the effect that it was not an approval, but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing, Your Lordship, then the provisions of Article 118 of the Constitution will then apply, because they will still need to conduct public participation as required under Article 118. And Article 118 provides that public access and participation. So it says that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So, Your Lordship, even if they escape the provisions of Section 6.4 of this Act, of the Public Appointments Parliamentary Approval Act, then they cannot circumvent the provisions of Article 118, which requires that Parliament must still, in all its businesses, involve the people. And Your Lordship, there is an authority that I want to rely on, and that is Legal Advice Center and two others. It is in our case, in our bundle of authorities, versus the County Government of Mombasa and 4 others. It's a 2018 decision. And Your Lordship, I just want to quote in verbatim a very small part where the court said that the purpose of permitting public participation in the lawmaking process is to afford the public an opportunity to influence the decision of the lawmakers. So, Your Lordship, assuming that we were to take the proposal that they said that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the deputy president nominee. And Your Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the Speaker is elected. They are directly elected by the members of Parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude, is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. Your Lordship, our submission is that it was not open in law for the Senate to take the approach of the plenary. And my learned senior Ochil Dudley had already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if we were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize, read section 27(1), which provides that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, Your Lordship, under Article 27, there is a benefit that has been, under Article 145.3, there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a route that is provided here, it will actually amount to a discriminatory act in the following sense, my Lord and my Lady, that it means that the Senate will be deciding. There is no criteria as to when the special committee will be applied by the Senate and when a plenary will be applied by the Senate. And Your Lordship, what that means is that it will depend on whether the Senate actually, you are in good books either with the Senate or whoever who is in charge of those impeachment, because there is no procedure that actually provides that under these circumstances, a special committee must be undertaken, and under these special circumstances, then the plenary can be undertaken. It is left to the Senate to determine at whichever time they are going to use whichever mode. And Your Lordship, that has been demonstrated even in the impeachment of governors, where you find that some governors are subjected to the plenary, others are subjected to the special committee without any justification why this was used over that. And therefore, the purposive interpretation and holistic interpretation of this article will yield a conclusion that at all times when it comes to the impeachment of the president or the deputy president, a special committee must be constituted by the Senate for purposes of hearing, investigating first of all whether the charges have been substantiated before a recommendation is made to the Senate. And finally, the other rule that I want to rely on is on the Latin maxim that expressio unius est exclusio alteras. So, Your Lordship, that provision basically means that what has been expressly provided under the Constitution, any other thing is excluded. Your Lordship, the framers of the Constitution, if they wanted to have both modes available, then, Your Lordship, there was nothing difficult in them saying that either they investigate by the committee or by plenary. They expressly excluded the provision of a plenary, because what the Constitution wanted is a process where the president or the deputy president is given an opportunity to, first of all, for the Senate to first of all investigate by the committee, and finally that the matter be deliberated in the Senate. So, Your Lordship, in light of those brief submissions, we do pray that this honorable court finds that the impeachment of the second deputy president was unconstitutional, invalid, and null and void. Those are my humble submissions.
Can you in just 1 second tell me the remedies we're seeking in this petition?
Yes, Your Lordship. In our petition, we have several prayers that we've sought, and the first prayer is a declaration that the appointment of Professor Kithure Kindiki as the Deputy President of the Republic of Kenya was invalid, null and void for the reasons that we've given in terms of there was no public participation. Your Lordship, another prayer that we did seek is a declaration that the National Assembly and the Senate were under an obligation to undertake separate public participation in respect to the impeachment of the second deputy president. Further, Your Lordship, another prayer that we sought for a declaration that the public participation that was conducted by the National Assembly on 4th October and 5th of October was not proper, effective, and meaningful within the provisions of Article 10 and 118 of the Constitution. And finally, that the impeachment process of the first interested party, being the second deputy president, was invalid, null and void. Those are the submissions. And Your Lordship, of course, cost of this petition.
Thank you very much.
And we do support the position that was taken by the first petitioner. Most obliged, my Lord.
Thank you. Mr. Omoke.
Your Lordship, I would like to present my petition on a fresh day. So I'll let Ms. She can go ahead.
Are you revising the directions which we made without application?
No, Your Lordship. I would like for the second petition she can proceed.
So why do you want a fresh day?
No, I can still carry on today.
Yes, my name is Teresia Wanjiru Kimoto Makazi from Tess Kimoto and Company Advocates Kerugoya. I'm for the second petitioner. So my petition is the one dated Okay, thank you. It's the one dated 25th September 2024. And in that petition, we are seeking several orders. And in those orders that we are seeking, one, we are seeking that the then Honorable Rigathi Gachagua, there be a declaration that the constitutional rights of the applicant, who is the petitioner, provided for under Article 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. And that the first respondent, who by then was the current Deputy President, be ordered to issue an apology to the NIS members and staff due to the utterances and speech made on the 26th June 2024. Cost of the petition and any other relief the court may deem fit. Of course, we wish to say that our petition has not been opposed by anybody. And we rely, of course, on the facts in support of the petition and our supporting affidavit as it is. We also wish to say that the reason why we had done an application to stop the impeachment proceedings is because
I don't like doing this. But clearly, Ms. Kimotho's petition is overtaken by events. The petition sought an apology by the second deputy president to the NIS. That did not happen. The impeachment occurred. A vote was taken on that question, and it is the subject of the first petition argued by Senior Counsel Paul Mwite. So Ms. Kimotho should sit down. Thank you.
No. We are opposed to that because that's not true. The apology we were seeking is an apology from the deputy president, whether he's sitting or not sitting. So we are very much in place. And again, we also wish to as I proceed before I was interrupted by my senior, I wish to say that we are also in support of, we are against the process of impeachment. And we are going to say why, if I'm allowed to say. The reason why we are in support of, why we are against, the impeachment process is that the grounds that we relied on in our petition are the same grounds that were being litigated by the Senate. The judge, when we went to, our petition was passed, E013. When we went to the High Court at Kerugoya, we raised these issues. The Senate had not yet started the process, the impeachment process. And so we felt that if we were hard fast, then this whole issue would have taken a different turn. Because once a case is pending in court, once the issues that are being raised are the same issues being raised in the Senate, then we ought to have been hard fast. And that's what we have been raising from the application that we did, and even in this situation when we are arguing our petition. We again say that if you look at the entire process, any person who goes to court must be heard. That's an Article 50, fair hearing. Then if the same issues that are being raised here are raised there, then of course there's an issue. It shows the senator, because we served the Senate, and the speaker clearly acknowledged that there's a petition going on in Kerugoya, but they ignored. This can only show their minds. They had made up their minds. And that's why now we are in support of the petitioners against the entire impeachment process. And this point is very, very important. Again, if you look at when we were consolidated, there came the issues again that are being raised here. Public participation, which on our part, we are supporting. We are saying the public participation that was done was not done well. His Excellency Rigathi Gachagua, His Excellency the President of Kenya, William Ruto, are people who are voted by Kenyans as a duo, not individually. So now when His Excellency, one duo, one person, one part of that duo is subjected to impeachment without the same process that was used to bring them to power, then that issue violates the Constitution. And why are we saying this? If you look at how they were elected, polling stations were everywhere. Each constituency, each polling stations in the wards, people were allowed to vote. So now when it comes to public participation, in where now we want to remove one duo, why are Kenyans not being told, come, let's get your views on the removal of one duo that we elected? How can we be told we don't have a right to be here right now? We do have a right, because if Kenyans did not participate equally as they did participate during the elections campaigns, then the process, any public participation that he said was done here was a sham. The second issue, why we are in support of this petition. Again, you can see how, and these allegations that are in public domain. In fact, in our petition, we are accusing the Attorney General of these issues. Everybody kept on saying the MPs were given 500,000. The senators were given 1 million. These are allegations in the public domain. Can we say this process was fair when people out there are claiming there's bribery? We have seen several talk shows, people continuing saying these issues. So we are objecting to that process that was done. The other point that we wish to say is, okay, again, that was repeated, but I can emphasize, on the day of the Senate, we see the then Deputy President, Rigathi Gachagua, falling sick. We have served, is our order, standing there, the Speaker of the Senate acknowledging that, yes, we've been served with an order. Then suddenly the Deputy President becomes sick. And then what happens? The Senate does not care. They give a few hours, a few days, and then say, we will proceed, whether he appears before us or not. We go back to Article 50, fair hearing. Fair hearing means, however that person is, he must be allowed to give us his side of story. Kenyans were waiting. Kenyans were watching the TV. They wanted to hear His Excellency Rigathi Gachagua tell us, we voted for him. We want to know what happened. What happened, yet we voted a duo. So this chance we were not given. What we saw was in Senate, people come in and the lawyers speak and other allegations, paperwork. So Kenyans would have expected to hear his side of story. So in that, we say he was not given a fair hearing, and therefore that impeachment process was not conducted the correct way. Yes, I think my points, those are my few points. They are very fiery, so I don't want to keep...
Of course they are.
Yeah, I don't want to spoil anything. That's all for me.
Thank you. Yeah, they are fiery. Thank you very much.
Okay.
Yes, thank you.
My Lord, just forgot to say that Kerogoya is in Kirinyaga.
Oh, yes.
Correct.
Can you see how many people are yet to submit? How many?
My Lord, there's the third petitioner.
Mr. Kibe, where is Mr. Kibe? Can I see how many are yet to submit? So we'll proceed until 6.
Did your lordship give an indication of up to what time we will be sitting?
6. 6.
Today?
Yes. You want us to amend it?
No. I was just asking for clarity on up to what time we will be sitting.
You know, these people, I don't know where the councils have arrived from, because when we were taking quorum, they were not this large. Some people have just appeared. Some of the councils have just appeared now, because you spoke about 8 people. 8 councils, yes. And then after that, we have had now, I see quite a number of councils are here. I don't know, maybe.
Probably a misunderstanding. The 8 councils I stated are the 8 councils appearing for the first petition. There are many other petitioners. And these councils are for those other petitioners.
Yes.
But looking at the number, it's a matter entirely in your lordship's
So we can do up to 6. Then after that, we can make further directions.
Okay.
Yes.
Thank you.
My Lord,
My Lord, just so that I may get some clarity, the two of us going, 6 o'clock, that's in 30 minutes. It would be better if we took a proposal to get directions from the court, because I would definitely need more time. Unless maybe I might be lucky that there's one of us who can do it in 30 minutes to make 6. Okay, he's willing to do 30 minutes.
Okay.
Your Lordship, once again, my name is Murara Moke. I am the 43rd petitioner. I filed a petition on my own behalf, and I was deeply offended by the manner in which the impeachment process was being conducted. And therefore, in compliance with the Constitution, I came before this court to defend it. It was not about my political alignment at the time, but about the Constitution, and that's why I'm here today. My petition is E027 of 2024. I have a supporting affidavit sworn on 9th of October 2024.
E0.
Sorry?
E047.
E027 of 2024. The same date. On the same date I saw the affidavit, 7th of October 2024. I filed very brief submissions dated 1st of April 2026, in which I sought to address 2 issues, as I do not wish to repeat what the first petition has already submitted on, but I fully support the submissions presented by the councils for the first petitioner. And I will proceed to make a few additions. On the issue of public participation, I personally attended the public participation exercise at Kiambu Social Hall. I'm a resident of Kiambu County, although I'm born in Kisii. I attended, and I can confirm that the form that was provided to the participants only summarized the allegations against His Excellency Rigathi Gachagua without provision of any particulars or any evidence in support. So I can confirm as a participant, and there is no response in opposition to my petition to challenge that position. There was no evidence in support of the various grounds of impeachment as presented to the public. Secondly, there were no attachments of His Excellency Rigathi Gachagua's response, which at the time had already been filed before the National Assembly. It was never provided to the participants. And as earlier on stated, the public was only being asked to give an opinion of yes or no, and only a very small provision at the bottom of the form to say any other thing. I also would like to indicate that the manner in which, rather the form, the language was only in English. And as you know, in this country, we have two official languages, English and Kiswahili. Earlier on in Swanya's submissions, he did talk about the BBI case. Actually, in that case, I prosecuted that point on providing different languages when it comes to public participation, especially on an issue that is so important as this impeachment. It was only done in English. There's no explanation why it was not done. They could have taken time, but because there was the hastiness with which this process was being carried out, of course, there was no attempt to provide for any other language. In my petition, I gave a background to the impeachment process, and I did find fault with the lack of partiality on the part of the Speaker of the National Assembly and the Deputy, and the remarks they made prior to the impeachment process. Starting with the Deputy Speaker, she did say, mimi mwenyewe nitampeleka nyumbani in a public rally. Around the Hansard is in reference to the impeachment proceedings. I believe it should be before. Without it before this court would mean that I'm not able to point out the specific date, but it should be before the court. The one for the National Assembly. I'm making reference to the one in the National Assembly. It's 5th of October, 2024. Sorry, Your Lordship, 8th of October, 2024. In that particular Hansard at page 18, I picked the remarks that were made by the Member of Parliament for Suba South, Karoli Omondi, at page 24, I picked remarks that were made also, I forgot to mention the Member of Parliament for Mavoko, Patrick Macau. Actually, that is at page 24. Then at page 42 and 43, you will find those of Catherine Omanyo. I will not go into what they said, but I would ask the court to look at some of the issues they said, which to me were personal issues they had with the deputy president, or some long-held grudges, which they used as their reasons for endorsing the advancement of the impeachment to the Senate. This being an impeachment trial, which, as we said, in the standard set in the Wambora case, which requires a very high standard, and the Constitution, which also talks about grossness and seriousness of the misconduct and the violation. You cannot introduce any other ground, even if that's what is your reason. You have to debate, you have to vote on the impeachment on the basis of the grounds that have been stated in the motion. So that is another failure, which on that basis I would ask the court to find that the impeachment failed to meet the standard, the constitutional standard. It has to be the constitutional standard and threshold, and therefore it ought to be declared null and void. Your Lordship, I would now move to present on the issue of lack of legal mechanisms, or rather legislation, to operationalize Article 150, in this case, of course, which incorporates the other articles on impeachment. Again, on this issue, I did make a presentation in the BBI case on the lack of legislation. In that particular case, the issue was lack of legislation for collection of signatures. And that was an important issue in the BBI case. And the court agreed, and I would ask this court to make that finding, which is extremely important, that this kind of a process, being so important, must have legislation. And I would like to state why it is important. For instance, when you look at the provisions touching on the election of a president and a deputy president, it's very clearly provided on the judicial review available to any party who is dissatisfied with the process. It's elaborate. It has to be that you come before the court, you raise your issues, the court makes a decision. Thereafter, then whoever is elected is sworn into office. So the Constitution, in a way, has actually enforced some conservative relief. However, that is not provided on the issue of impeachment, and therefore, just as important as the process of occupation of that office, should be the process of exiting that office. And that, therefore, would require legislation to address that issue. We were, before this court, we argued on the issue of conservatory orders. Your Lordship, it leaves us in a difficult position if this court was to find that this impeachment process was unconstitutional. How do we cure the fact that His Excellency Rigathi Gachagua was hounded out of office, replaced, and now he's left without a solution? Because if we say, for instance, that if we were to order him back to the office, the kind of situation we face is difficult. And that is why it's important to have legislation to provide for room for judicial intervention before the swearing in of the new occupant of an office, if the court was to ever confirm the impeachment process. It also would also aid the person, the incoming, not to come in under the cloud of illegitimacy. Because as we are here today, we have issues have been raised by my colleagues about the fact that the replacement came into office hurriedly without any safeguards. There was no vetting, because it being an appointee, then it reduced him to that level of requiring vetting. While for an elected deputy president, the vetting is with the people. They vet and they vote. So I would say that this is an issue that leaves us in a, which actually paints a cloud of doubt on the efficacy of fair hearing in the Constitution. And my hope is that the judiciary would acknowledge that the fact that we do not have conservatory orders in place was a problem. And I would explain why. In the Constitution, there is a line of succession provided that if the president is not there, the deputy president would come into office, would act in that period of vacancy. If the two of them are absent, there is a Speaker of the National Assembly. And the fact that in the ruling on conservatory orders, we did recognize the significance of this office. Therefore, it will become so important if we had legislation to even provide for such situations. What should happen? In my petition, I have only asked for 2 reliefs: a finding on the unconstitutionality of the process, and on the issue and the question of a lack of legislation, which as I submit before this court and ask this court to align with your colleagues in the BBI judgment, that lack can render this kind of a process flawed. I so submit to your lordships and my lady.
Thank you.
My lords and my ladies, I see it is around 5:50. I'd requested court for 20 minutes, but based on what has been submitted, I'll only take 10 minutes because I wish not to repeat and regurgitate what my seniors and the petitioners who have come before me have already told this court. Your Honor,
I don't think we'll be able to hear you now because there's another petition we are mentioning and time is well spent. Just give us a few minutes, we'll give you directions.
Much obliged.
So I think our time is well spent. We have to adjourn to the next hearing date, which is 7th of May. We'll proceed with the petitioners' counsel who have not submitted, and thereafter we'll proceed with the respondents on 7th of May. Should I suggest that we start at 9? Yes, 7th of May at 9. So with that, I think, yes.
No, I was waiting for my lord to finish giving the directions.
Yes. Yes, I've finished. We'll adjourn until 7th of May at 9. By that time, I think we'll have the services of the ceremonial hall.
My lord, as your leadership, the court will recollect that when we last appeared before this noble court on the 24th of February, 2025, I stated to this noble court on record, on behalf of His Excellency regarding Gachagua, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency regarding Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish again, my Lord, your leadership, to reiterate that position on record. My Lords, the prayers of the first petition are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law. Finally, for the period of 2.5 years that His Excellency regarding Gachagua served as the second Deputy President of the Republic. Okay. It is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment cannot and could not have been retrospective. That is the solution.
Wacha, kid you not, 39 made it to go to Miami. I'm from Kiamba. I've never seen snow. 7 times out of 10, passengers will be like, that voice of yours is gonna make you a lot of money one day. I was a desk assistant, I was Kadayamoko. There was this small story, 10,000 people being killed every single day. That was one of the reasons I wanted to come back and tell the story. We hear shots being fired, boom, boom, boom. I'm so privileged to have the access to these people. Kwa vile kwa ground, mambo ni tofauti. I'm like a phoenix. I always rise out of the ashes. Welcome to I Am.
His Excellency Dr. Jonathan B. Chelilim EGH, Governor of Uasin Gishu County, wishes to inform all property owners that a 100% waiver has been granted.
The Speaker for the National Assembly even quoted a verse from the Bible about
of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission, and that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this report to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. You know, if you look at paragraph 8, 9, and 10, and 11, and they appear from page 8 of our written submission. Paragraph 8, the Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8 October 2024, which then passed a resolution that the plenary would hear and consider And I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution and the standing order. It was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President the first petition the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced and scheduled on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination, this report will be taken to the order of an Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by the Gachagua. And also RG 12, volume 9, pages 1752 to 1758. Lord, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their mind to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the prime minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that they are breaches of the Constitution, and you will be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petitioner, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kyoko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case, the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet through the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I said, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. Well, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. Lord, if you go to page 11 of our written submission, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. Lord, those 8 issues are the ones we have divided amongst ourselves as council appearing for the deputy president to be addressed by each one of us. But Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different countries. Now, Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. The second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the deputy president a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the deputy president was denied a fair hearing. Fair hearing is cardinal in our philosophy of justice, time immemorial, even prior to the 2020. And the third one is whether the overnight clearances for the replacement deputy president evidenced a predetermined process compounded by the violation. Whether that was unconstitutional. My Lord, your leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, which is the motion. My Lord, in Martin Nyaga Wambora and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional court. My Lord, your leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing in our Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution, or other they did. The word gross must carry the true intention of the drafters of our. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case, deputy governor, may I say, not just the deputy governor, the law that this of the court will be laid down or reiterate will apply to the impeachment of the president himself. It's a very weighty issue, so this court is asked to confirm. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly grossly violated. Here, my Lord, in the case before this honorable court. The allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the bill. The court nullified Section 132 of the bill 5 years before the Deputy President's election to office. The date of the impeachment motion alleged that the Deputy President had violated that nullified law, warranting his removal from office. By impeaching the Deputy on the basis of a section that had been nullified by this, what he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. And my Lord, you find that authority, paragraph 62, case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. And you find that in Exhibit RG3, Volume 6, pages 745 to 747. My Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS under the Constitution 239, Sabbatical 5, is supposed to be under civilian oversight.
No, you want expectations.
And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in part 3, civilian authorities, the heading, effective surveillance authority. They then say that the cabinet secretary will be the civilian authority oversight. The cabinet secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Leadership, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Brigadier Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the deputy president had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering. The deputy president explained that no valuation had been done, so where the National Assembly, Honorable Mwengi Mutusi, got 5.2 billion is anybody's guess. If you want to charge somebody, you present them that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Dirito Gachagua. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Bipingo Beach Resort, Queensgate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my lord, in RG2, volume 2, pages 211 to 214. Lords, although the mover of the motion listed 32 companies associating them with the petition, first petition, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you find that in RG2, volume 2, pages 214 to 218.
Tulikuwa nayo, tulikuwa tunataka around 60 youths.
The Speaker of the National Assembly, again, a good professional colleague who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you'll find that as message of the Senate, number 025 of 2024, approval of special motion, RG3, volume 6, 745 to 744. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that, one, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)A of the Standing Orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those set out in the motion. The impeachment was converted into a vicarious assault on family rather than investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go through the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability. Pushed through with uncharacteristic speed, with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings on the basis that the petitioner offended the president rather than the Constitution. What the 2010 Constitution provides is violation of the Constitution. In other words, the president must take time and choose his deputy. And Lord, I don't need to take time to go through what the country was put through between His Excellency Daniel Toroitich Arap Moi and his Vice President George Saitoti, dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And, my Lord, I will not repeat the Wambora case, but I would state the impeachment motion was replete with generalized statements and supported allegations, hearsay, outright lies, lack of particularization and specificity as required by Article 145. My Lord, the exposition on all that is set out in paragraph 36 of our written submissions, and I will not take the time of this court going through them. I invite the court to read through it when you retire. Despite this glaring and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment motion was tabled in the National Assembly, the first respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds in the impeachment motion met the requirements of the threshold. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specific and accuracy requirements of the standing orders, seems to have been motivated by Parliament's bias and reckless haste to pass the motion as quickly as possible in order to shield the process and its obvious serious rules to the judicial review. It is our submission that was the real reason for the rush. My Lords, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that. The motion thus violated Article 50, Sub-Article 2B, and Article 50, Sub-Article of the Constitution by setting out vague allegations, criminal conduct, including the Deputy President had violated I repealed sections of the penal, the leadership and integrity without ever charging. Overall, the impeachment motion of the first correspondence communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 1. The Lord, you see over RG 1, volume 1, pages 2 to 41, and RG 8, volume 7, page 969 to 976. So, my Lord, that is all I wish to say about A. Let me very quickly move to C. So that's why we want to my Lord, issue C. Is there a problem with the card? See, hold on. I'm listening to the my Lord, issue C is whether the Senate.
I need to remind you about time.
Only another 10 to 15 minutes.
You already have barely 5 minutes.
Yes. Move yours quickly. See, my Lord, which you find at page 40 of our submission, is whether the Senate misled by its misinterpretation of Article 145, rushed the Senate, my Lord, recognizes the right to a fair hearing in considering a petition for removal of a person from office, because they say so in their standing order number 81, the right to appear before the committee, the relevant. That is in standing order. Yeah, so we are inviting you tomorrow. Whenever the Constitution or any other written law require the Senate to consider a petition or a proposal for the removal of a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee. The petitioner here was denied that opportunity to appear before the committee. And the importance of the committee, my Lord, is that the committee has got less members. The law gives the subcommittee 10 days to investigate. And therefore, the deputy president would have been able to appear before that subcommittee with his evidence, with his lawyers, and would have been able to argue. By bypassing the setting up of that committee and assuming that the 10 days related to the plenary, which they did not, the deputy president denied a fair trial. Lord, when the deputy president had all along appeared in person and signaled his willingness to take the stand, he became mute. And all of us are human beings. Lord, illness does not come knocking. One is just taken ill. And he was taken ill after very stressful, strenuous proceedings. National Assembly and the first day in the Senate. Lord, it's a very stressful situation for the deputy president to be deprived of that position to which he had been elected by over 7 million people. Lord, when counsel for the deputy president stated that he had been taken ill, the speaker ruled of the Senate I said we were going to execute with military precision, owing to the fact that we need to conclude business today. And he said I had indicated that I could not get hold of the client or the doctors at once because he had been admitted to ICU. First, the 10 days did not apply to the Senate. That was a misreading of the Constitution. But secondly, there was time we were requesting adjournment up to Tuesday to see about the Deputy President. But the Speaker said they could only adjourn up to Saturday. His proposal for adjournment to Saturday was shut down by the senators voting and saying they would not allow adjournment even. And no reasons were given for rejection of an adjournment to the following day, Sunday. Lord, this was a serious violation of the rules of natural justice. Lord, adjournment by the Senate is discretionary, but like all discretionary power, the discretion is to be exercised objectively, judiciously, and upon reason, not arbitrarily, capriciously, or unwillingly. Here, falling ill on the second day of a grueling two-day hearing, Deputy President sought a 3-working-day adjournment to Tuesday, 22nd October, to enable him to recover and appear for presentation. The Senate defeated that proposal to adjourn until Saturday to see if the Deputy President had recovered. Egged on by the National Assembly, the Senate insisted on proceeding in the Deputy President's absence. My Lord, you will see at paragraph 83 of our written submission the case of the then Major General Peter Kariuki as Attorney General. It is number 3. It is paragraph 3, page 250 in our bundle, where the Court of Appeals said the appellant's request for a 3-working-day adjournment, 3 days adjournment, to instruct counsel was denied. He had been held incommunicado without access to a lawyer for over 147 days. He had less than 10 hours in total, and in a prison setting to instruct his lawyer to prepare his defense. Overturning the court-martial decision denying the adjournment, the Court of Appeal explained, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion
that although the same principles are relevant in respect of application for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right, the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for the adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. There are very many cases cited, even in the court of law. My Lord, again, I had the privilege of arguing this case before the court martial back in 1983, following the attempted coup, and also through the High Court, through the Court of Appeal. The conviction by the court martial was quashed on the basis that Major General Kariuki, the commander of the Air Force, had been denied a fair trial. My Lord, in the interest of time, I was going to highlight the speed with which the whole process from the word all the way through was done, but including the rest of it. But I invite the court to read our written submission. I want to mention that after hearing the Deputy President on the 8th of March, finishing at about 8 p.m. On the date that the National Assembly considered this meeting,
the meeting is about
they voted to impeach
tunapeana grants za kuanzisha biashara
close to 9 p.m.
kesho saa 2.
The normal working hours are daylight hours. How is it that the National Assembly has made their resolution to the Senate? But it was transmitted at night. And the following day, the Senate set the date to commence the proceedings. Equally, when the Senate, after depriving the Deputy President fair opportunity to defend himself, impeached on 5 out of 11 grounds. Equally, they had to transmit the impeachment resolution back to the Senate close to midnight. My Lord, I'm inviting this court to see this breakneck speed. Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. On a Friday, which is not a normal sitting. Any thinking person will wonder how the Speaker of the National Assembly, a good friend of mine, Senior Counsel, how was he able to ask the Senate? Although the resolution of the Senate was being transmitted back to the National Assembly after midnight. Between midnight and the following day, His Excellency the President had time during the night to get clearance for the person he wanted as his Deputy President from the ethics and anti-KRA. These are public institutions In fact, the Electoral Commission did not even have commissioners to make a decision clearing the choice of the deputy president. But I mentioned this to demonstrate the unholy rush. I invite this court to see through the smoke screen, cotton thrown about by the National Assembly and the Senate to confuse issues. They were mere. There was no attempt to address serious violation of the Constitution. Lord, I hand over to you.
Thank you, my lords and my lady. My name is Elisha Ongoya. Number one, I have reflected on a number of unjust trials in human history. The trial of Sir Thomas More, the trial of Socrates, and even the trial of Jesus Christ. One element characterizes these trials. When you read history, there are trials that are carried out with predetermined outcomes. Those who are taken through the trials are taken through the motions for the sake of it. My learned friend, Mr. Wachira Maina, whom I've had the chance to work with, reminds me all the time that behind every constitution lies a moral idea and a moral expectation that there will be good faith compliance with the commands of that constitution. In fact, Mr. Wachira Maina informs me, and I believe him, that in management theory, there is a concept described as malicious compliance. It informs me that there is a legitimacy gap that is wider than the Pacific Ocean between good faith compliance and malicious compliance. That the first petitioner was taken through at the National Assembly and the Senate of Kenya passed the test of malicious compliance. The danger of allowing malicious compliance to go unredressed is that it injects an irredeemable legitimacy gap. The second inspiration that I wish my lords to bear in mind as you determine this matter was set out by the Court of Appeal of Wambora and 3 others versus the Speaker of the Senate and 6 others. This matter traversed our entire superior court system, and therefore very emphatic of which particular court I'm referring to when I refer to the Wambora case. So I'm looking at the Court of Appeal 2014. In that matter, the Court of Appeal began by setting out what would inspire it. In paragraph 3, case at the Court of Appeal observes that, I quote, no parliament, no official, and no institution is immune from judicial scrutiny. I say this because to such other debt as you shall defer us to, some people will take this stand and tell you that there are political issues here that I knew from your scrutiny. The second inspiration that the Court of Appeal set out in the Wambora case, not Parliament, not the Executive, not the Judiciary, which is supreme. It is the Constitution. I stand here to canvass one substantive question, a continuation of the threshold concerns surrounding the motion, particularly as eventually approved by the Senate. Your brother, Mr. Justice Bahati Mwamuye, has observed in the now famous Kawira Mwangaza case good law or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. That's the big risk that our constitutional order is subjected to if we allow what happened in this country, culminating in the resolution of the 17th of October 2024, to stand. It's a threat to confidence in our constitutional democracy itself. Allow me just to reiterate one question that has bothered me and my learned senior colleague, Ms. Senior Counsel Paul Mwita, has touched on it. On 17th of October 2024, when you go through the Hansards of the Senate that I will draw your attention in a short while, the Speaker of the Senate delivered a communication from the chair, an actual ruling, which informed the members that the first petitioner was in fact indisposed and not available to be heard as guaranteed by law. My lords will agree with me, it requires extremely compelling reasons to insist on proceeding with a case where the subject of that trial is indisposed. It must be exceptionally compelling reasons, not just reasons. When you deliver this judgment, because this matter, I've had the misfortune of sitting on the front benches of this case from the time this matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because my learned colleague, Mr. Dudley, will take you through the timelines for impeachment in Article 145, as read that 145. But even after the Speaker erroneously said, we have a timeline of Saturday. They had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. I would want to read in your judgments, my lord and my lady, through what logic this court will allow that decision to stand, if no other decision, that particular one. That for no reason, we are not saying the heavens will come down fully. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason They simply said, we will not give him the benefit of those 2 days that the Speaker has said we still have. Let's go on record. The Speaker too was wrong. But there may have been some veneer of good faith. If they had said it's okay, because we have 2 days, let's give him the 2 days for whatever it is worth. They said, even that, we are not going to give it to him. Tasked to bring to your lordship's, ladyship's attention are the following. Number one, Article 150 clause 1 of the Constitution sets out the constitutional textual threshold for removal of a deputy president from office by impeachment. And it says is on the grounds of gross violation of a provision of the Constitution or any other laws. Secondly, it says is on the ground of serious reasons to believe that the deputy president has committed a crime under national or international law. Serious reasons. I'll be making out a simple case that the National Assembly really disappointed the country. To approve a motion that there are serious reasons to believe that the deputy president has violated a provision of the law, Section 132 of the Penal Code, which has been declared unconstitutional, null and void, is a locus classicus of lack of seriousness in the reasons. And thirdly, the standard of gross misconduct. Let's face it, my lords, my lady. The drafters of this constitution could as well characterize these wrongs as violation of the constitution, because that's also a wrong, or reason to believe that the DP has committed a crime, or misconduct. Those are wrongs. But they were particular to add these descriptive words, gross, to the violation, gross to the misconduct, and serious to the reasons. The conclusion I draw from this is that they set a very high threshold for removal of a deputy president. Our courts have followed cue. I would start with the Supreme Court, sample 2 decisions there. Go to the Court of Appeal, sample 1 decision there. Then go to the High Court and sample 1 decision there. From the Supreme Court, the decision of Sonko versus the County Assembly of Nairobi City and 11 others. Yes.
What you do after
yes, we do. Correct. Okay. I'm highlighting, my lord, so I was avoiding reading them. So I'm drawing because if I have to take you through the pages, then it means I have to actually take you through the submissions themselves. I'm just highlighting salient aspects of those submissions so that we save on time. Thank you. So that in Sonko versus the County Assembly of Nairobi City, I beseech this court to look at paragraph 161 of that judgment.
This month,
the court the Supreme Court observed that the grounds for impeachment and removal from the office must be substantiated. The grounds for impeachment and removal from office must be substantiated. It means, my lords and my lady, the motion mover and his supporting cast of witnesses must show us where is the supporting evidence for each of those grounds. They must show where the supporting evidence is. Because substantiation simply means adduction of adequate evidence to lend credence to the ground. The Supreme Court then sets the standard as what has now been called the intermediate standard, not so low as to be on a balance of probabilities and not so high as to be beyond reasonable doubt. You will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They've been removed on similar grounds. And you will see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, and I quote, clearly, all the words used to describe gross express some extreme negative conduct, not just negative conduct. It says extreme negative conduct. And it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature that would warrant removal of a judge from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, sets that standard in the Martin Nyaga Wambora and 3 others. I'll just refer you to paragraphs 42 through 45 of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's one I have in mind. Look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges.
Nimekuwa na busy day, siku manage kuongelesha watu wote huko Irondi wakuje kesho.
In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were two consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you'll find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I would invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had 1 witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam in chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam in chief and perhaps the 3 hours for our cross-examination of the National Assembly witnesses and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We're just ordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by way of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying of the time you have allocated us, We have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in examine chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be understood. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I will start with the ground number 4 of the impeachment motion. The particulars of that ground will be found at paragraph 34 of the motion itself. The particulars of ground number 4 will be found at paragraph 34 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Rigathi Gachagua. The particulars state that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. It is a requirement in impeachment proceedings that the impeaching house cannot introduce any new grounds at the Senate stage. They are held to account on the grounds as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. One, what does Article 160, Clause 5 of the Constitution provide? It provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground number 4 and particulars of paragraph 34, it is alleging that the threat to take a judge to the Judicial Service Commission is a violation of Article 160. The lawyers are here, they will tell us. In fact, some senators are actually here. They will tell us. How does Senate read Article 160, Clause 5 as against Article 168, Clause 2? Because Article 168, Clause 2 constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168, Clause 2 process, how can that be a violation of Article 160, Clause 5? I was taught many years ago, I hope it's still learning today, the Constitution is not self-annihilating. We cannot read Article 160 Clause 5 to destroy Article 168 Clause 2. So that the National Assembly brought a case to the Senate that a claim by the Deputy President that he is going to file a petition against Justice Esther Maina is a violation of Article 160 Clause 5. The Senate approved that ground for the removal of the Deputy President. Now, let's not lose focus of this, my lords. The express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If you look at page 60 of the Hansard of 16th October 2024, it's on the attached the affidavit of Jeremiah Nyegenye as Annex JN10. The following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question. Do you still stand by that part of your allegation that he has not presented the complaint to the Judicial Service Commission as at that date? The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that he's claiming the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it be said that in view of this concession by the motion mover, that ground had been substantiated, that it passed the threshold? The third aspect I want my lords to reflect on when you retire, you can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. A judge has had a case and delivered a judgment and become functus officio. Can a verbal criticism of the manner in which that judge conducted herself in that case constitute a violation of the decisional independence of the judge? That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Can a verbal criticism of a judge, because of a decision she has already rendered and become functional official, amount to a threat to the decisional independence of that judge? Which decision? She has already rendered the decision. I submit to my lords that it is actually good democratic practice to subject judicial decisions to heightened scrutiny. It is good practice. It grows judicial accountability. And therefore, what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. The two grounds that I want to deal simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 5 accused the Deputy President of gross violation of Articles 3(1) and 148(5)(a) of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the Deputy President, that there were serious reasons to believe that the Deputy President had committed a crime under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Those were the two grounds. So, a ground must be supported by particulars. That's what the Supreme Court has said. Then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Ground 6 had no particulars of its own. Instead, what the drafter of this motion, in his drafting wisdom, did was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, the drafter didn't supply particulars. Instead, he said the particulars in support of ground 6 are the grounds set out in the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific acts or omissions constituting the wrongdoing. The National Assembly went to the Senate and said, we are charging the Deputy President in the ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that the grounds, the charges in impeachment are framed in the same manner as charges in a criminal case. This court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR. The case of LKO versus Republic, 2022 EKLR. And the case of Etiang versus Republic, 2022 EKLR. I just refer to one because they make the same principle. Justice Ongudi said, and I quote, the problem I find in the charge sheet is one of multiplicity of charges. Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. This may result in violation of the right of an accused person under Article 50, Clause 2, Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that the acts in ground 1, 2, 3, 4 are the same acts that constitute the ground 5 and ground 6, these two grounds were bad for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the two grounds were approved by the Senate as constituting the basis for removal of the Deputy President from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particulars set out in 1, 2, 3, and 4, and ground 5 on the particulars set out in grounds 1, 2, 3, and 4, but acquitted the Deputy President of grounds 2 and 3. And remember, they gave no reasons for convicting. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chel Dudley, will take you through in a short while. Then finally, ground 1. Ground 1 accused the Deputy President of gross violation of Articles 10(2)(a), B, and C, 73(1)(a) and 2B, 75(1) and C, so 75(1)(c) and 129(2) of the Constitution, and Articles 47(1) as read together with Articles 131(2)(c) and D of the Constitution. In summary, my lords, these were the grounds that accused the Deputy President of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. My learned colleague, Mr. Tom Masharia, took the motion mover through cross-examination on this ground. You will find that at pages 88 to 94 of the Hansard of 16th October 2024. So a number of things emerged. I just summarize them. Number one, the motion mover confirmed that the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion mover confirmed that as a fact. Number two, he confirmed that the Kenya Kwanza Coalition was formed of pre-election coalition agreements involving various parties. Number three, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my lord, this must come out very succinctly from me. It bears that PA is the party whose party leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to sharing of government. And they expressly spoke about sharing government positions and sharing resources. You'll see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You'll see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You will see positions, the leader of Ford Kenya being promised the position of the Speaker of the National Assembly and certain cabinet portfolios and principal secretary portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question, therefore, is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that kind of manifesto or that kind of pre-election arrangement at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Sonko decision that I have just referred to. If you look at the High Court Sonko decision at paragraph 258, the High Court says an impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. If the people of Kenya had gone to the 2022 elections on the strength of these pre-election arrangements that talked about shareholding, it follows that they had a chance to revisit that question at the next election cycle. That's what the High Court is telling us. But, my lords, the more interesting one for me is at page 95 of the Hansard of 16th October 2024. You'll find the following very interesting conversation between Counsel Tom Macharia and the motion mover, Ecomas Mwenge Mutuse. I'll briefly take through the conversation, my lord, but you will take note of the pages and revisit it when you retire to do duty of writing judgment. Tom Macharia begins by playing a video to the motion mover and puts the question, who is speaking in that video? The motion mover, Mwenge Mutuse, responds, the President of the Republic of Kenya, Honorable William Ruto. Tom Macharia then poses the question, which words did he use? What did he say to the people of Murang'a? Mwenge Mutuse says he has appointed many of the locals into his government. Tom Macharia prods further, did he say, nyinyi watu wa Murang'a ni shareholders wakubwa wa hii serikali? Mwenge Mutuse says, yes, he did. The people of Kenya have no difficulty waiting to assess their president at the next election cycle in 2027 following this conversation. The question we want you to deal with is this. Why is the president's reference to the people of Murang'a as shareholders in his government acceptable political rhetoric? And a similar reference to the people of Nandi and Kericho, because those are the areas mentioned in the motion, by his deputy, an impeachable offense. It's worth noting that when you read the conversations I've told you at pages 88 to 94, you will find that the person who witnessed the pre-election pact in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, the National Assembly had no difficulty approving it now to become the deputy president. It is that uneven-handedness that we want this court to ask itself this question. Did the National Assembly find a wrong, then sought to establish who is the wrongdoer to be punished, then found the deputy president? Or did it find the deputy president, then asked, what wrong can we put on him to punish him? Which is what appears to me to have transpired in this set of circumstances. I have taken you through the 5 grounds that were approved by the Senate to demonstrate to you that they were bad for multiplicity. That's grounds 5 and 6. They fell short of the threshold as set out in Article 150 of the Constitution, as expanded upon through judicial interpretation. And therefore, generally, they could not found a motion for removal of the deputy president from office. While principally, therefore, beseeching this court to allow this petition, allow me now to invite my learned colleague, Mr. Chell Dudley, to take you through the reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the Speaker of the Senate fell way off the mark. Mr. Dudley, you're welcome. Thank you, my lord.
We have today received submission, the second respondent and the 8th. The speaker, no, actually the first respondent, that's the Speaker of the National Assembly, and the 8th respondent, the Deputy Speaker of the National Assembly. In their joint submissions, this, in summary, is the case they intend to put forward, and which will be the basis upon which they'll be asking you not to grant the orders I'm about to beseech you to grant. At paragraph 95, they begin by making concessions, which is always a good place to start. They concede that public participation is necessary for purposes of the impeachment proceedings that are before you. They concede that judicial oversight is within the powers of this court as regards the impeachment proceedings. They then muddle up their submission somewhat at paragraph 107 by stating that impeachment is a purely political process rather than a judicial one. At paragraph 107,
I understand your concern. Your number
they seek to limit the purview of this court's mandate by stating that the court's review of the decisions or the process does not include interrogating substantive merits of the impeachment charges. They, however, concede at paragraph 109 that this court has jurisdiction and power to examine whether the constitutional and statutory procedure for the impeachment was followed lawfully. That's paragraph 109. They concede as well at paragraph 109 that this court can examine the question as to whether the petitioner's rights were violated. I believe they are citing a decision of the Court of Appeal in making that concession. They then repeat at the same paragraph that the court cannot reevaluate or substitute or interrogate the substantive merits of Parliament's decision. And I'll be demonstrating to this honorable court why that is not the correct position. Having conceded that public participation is necessary, as they have at paragraph 95, they then seek to somehow circumscribe their concession at paragraphs 292 and 294 by saying that Senate did not require to conduct public participation. It's the boldest statement negating public participation I have ever had by a state organ. At paragraph 183, they make the point that fairness is required as a part of the process and that it requires careful consideration. And as regards what my learned senior counsel, Mr. Paul Muite, alluded to here earlier this morning regarding the events of the night when the IBC was consulted leading to the nomination of the current deputy president, they make the point at paragraph 380 that the National Assembly was not conducting a normal vetting process. It was a vote. In fact, they make the point that it was an election. Those are the words they use. And this is now to be found in the submissions of the first and eighth respondent at paragraph 68 to paragraph 70, that the president, in consulting IBC on that night, was not doing so as a matter of constitutional requirement, but was doing so as a matter of abundant caution. He was being careful. He didn't require to do so. Those are the points they make. Now, this court is imbued and clothed with authority, first and foremost under Article 22 of the Constitution of Kenya, and I don't need to read all the remedies that are stated and set out therein. But among those that are set out there and relevant to our client's case, one is compensation, E, and F, an order for judicial review. And then at Article 165, Subarticle 6, the High Court has supervisory jurisdiction where it is examining a decision arising from a quasi-judicial proceeding. And this is important for reasons that I will make known shortly. Now, I call this court's attention to Section 11 of the Fair Administrative Action Act, and it's an important act for many reasons, because whereas Parliament has made very lengthy submissions on many things, Parliament constitutionally talks through the laws it passes. This is a law Parliament passes directing what is to be fair in a proceeding such as this. And I begin first by making the point, and the respondents agree with me on this, and I'll be demonstrating where the submissions. They say that the Senate proceedings were quasi-judicial. That is the word they use themselves. And perhaps I think I should actually identify the exact paragraph where they say, I believe this is paragraph 292 of the submissions, where they say that the Senate was exercising a quasi-judicial authority. Yes, indeed, at paragraph 292 of the submissions by the National Assembly itself. And this is what they say. We submit that the Senate's function under Article 145 is not a legislative function, but a quasi-judicial and adjudicative role. The words quasi-judicial are the same words appearing, as I've stated, at Article 165, Sub-Article 6, but perhaps more importantly, under Section 2 of the Fair Administrative Action Act. And the Act begins by stating, this is the rationale for the statute by Parliament itself. This is an act of Parliament to give effect to Article 47 of the Constitution of Kenya. And this is what they say. Administrative action is defined as the powers, functions, and duties exercised by authorities or quasi-judicial tribunals. And so, by concession, by admission of the Senate, the decision, the process they undertook was quasi-judicial and therefore amenable to the Fair Administrative Action Act. And this is important because at Section 5, the statute says that in any case where the proposed administrative action is likely to materially and adversely affect the legal rights or interests of a group of persons or the general public, it then says what must be done. Amongst the first things that must be done is that there must be the issue of a public notice of the proposed administrative action inviting public views in that regard, public participation. Senate was required by the statute, by Section 5, to conduct public participation. They have admitted they did not do so. Number two, they are to consider all views submitted in relation to the matter before taking the administrative action. They were to consider everything said to them during public participation. They elected not to do so. They are to consider all the relevant and material facts. And D, where they proceed to take the action, they are to give reasons for the decision of the administrative action as taken. Again, they did not do that. That was not done. Now, and my good and learned senior here, Mr. Swanya, will be coming to give a few more details on the question of public participation, and I'll touch on a few others. But then, at section, I believe, section 7, subsection 2, this court is provided with a marking scheme. It is to apply when considering whether administrative action such as this met the test of the Constitution and of the law. I have been shocked in my own examination of the question to find that the National Assembly and Senate reached a mark. The examination mark was equivalent to my Form 2 physics examination, 0 out of 100. That is the figure they found. A self-supporting 0, and I'll proceed to demonstrate the points. Section 11, Section 7, subsection 2, I've read out to the court, states that the person who made the decision, and this is one of the criteria that the court is to look at, whether that person was not authorized to do so by the empowering provision. Now, you've been told, and as I've pointed out here, the respondents make the point that the president was only acting as a matter of abundant caution. Now, it is not in dispute, I think it is common ground between us, that the IEBC did not have commissioners or a chairperson. In 2025, the Supreme Court of Kenya handed down a decision. It is part of our list of authorities. It's called IEBC versus the Attorney General, 2025. At paragraph 62, this is what they say. It is uncontested and indeed a matter of public record that at the time of filing of the present reference, IEBC was not fully constituted following the exit of its previous commissioners. There was at the time no indication as to when new commissioners would be appointed. As such, the commission remained for all practical and constitutional purposes incapable of discharging functions that by law require the participation, deliberation, or approval of a properly constituted commission in accordance with Article 251. Required by law to do this, or whether he was actually acting as a matter of abundant caution, as it states. I call the court's attention to Article 88 of the Constitution of Kenya, the provisions of the IBC, the Elections Act, as regards what a nomination is, and with particular attention to the definition of the word nomination. Amongst the other things, the Speaker of the National Assembly had no authority to approve a motion that was based on a law that was declared unconstitutional, because it cannot be a high offense. It cannot be a violation of anything.
Content from a share belongs to another entity.